So, Dr. Pressman testified in the UK last May. That's their expert. They are married to him and his opinions. They are married to him and his findings. Did they ask him, did you say it's possible to fall into slow wave sleep within 5 to 6 minutes? They did not. We did, because we have the transcript. So, they have a dilemma. Either they knew he said that, and they knew he thinks in his own theories, based on his own research, that slow wave sleep can happen in 5 to 6 minutes, and they did not tell you that, or they did not know. I don't know which answer is worse. So, I told you we would have empirical evidence. This is Ben's sleep study. The sleep study, by the way, that he said he wanted, but they never gave him. How did that conversation go, too? Hey, guys, I'm going to testify in this first-degree murder case. I don't think I have everything. Well, here it is. Okay. Not only is it absolutely possible that you could fall asleep within their time period that they gave you, Ben, in his sleep study, fell asleep and was in slow wave sleep within 11 minutes. 11 minutes. So they can get up there with their flip charts and they can draw these timetables out. They didn't realize that it doesn't fit. You could easily fall asleep and enter into a parasomnia within their expert's opinion 5 to 6 minutes, or in Ben's case, he's showing it to you. He can do it. And he's not an average sleeper. He's got weird sleeping habits. But that's what they want you to convict him on. They want you to convict him because he's a little goofy. His parents like to dress up like King Arthur. That is the most tight-knit family, loving family, and it starts with his parents, and it goes to Ben, and it includes Meghan. So, is Ben capable, just from the evidence, from Anand, from his family, from his friends, is it consistent with his personality? And guys, this is where this part comes in the jury charge. If there was anything consistent with that, it comes out. So, instinctually, you probably have, as I mentioned in voir dire, a very difficult task. Meghan Elliott was an innocent, beautiful young lady, and she did not deserve to have the fate that she did. There's no question about that. But I asked you in voir dire, you're going to hear that. And even if you hear that, you're mad, you're upset. What about her? Does this just go away? No. There are other options that this government had besides first-degree murder, the highest charge other than capital murder. There are other ways to resolve a case like this. But your only question is on first-degree murder. Is it proven beyond reasonable doubt? You know, Ben, he is a funny guy. He is a witty guy. But he is going to live the rest of his life with the pain and regret and the remorse that at his hands, his sister is no longer here. The girl that he would wash windows with and ride the bus with, and he'd laugh with and he'd giggle with, the one that he watched over, the one he loved, he did it. He knows it. But he did not intentionally and knowingly commit this act. So at some point, this case is going to be over and the family has to pick up the pieces. But Ben will go on with that pain in his heart that never heals. The regret and the loss of his sister. And if you do not think that is punishment enough towards Ben, you've not been paying attention. You do not convict a young man, a 17-year-old, because of how he looks or because how he answers interrogation questions. You do it based on the evidence. And no matter how bad they try to twist the evidence and make it fit into some hole that does not match or make sense, no matter how much they do that, this is not proof beyond a reasonable doubt. Thank you, Judge.
Thank you. State you have 25 minutes for me. You may proceed. 25 minutes.
I love it when the defense tells me what my job is. That my job is to seek justice. They're right. That is my job. And that's what we've been trying to do. It would have been easier for me to ignore the facts and the evidence and just dismiss this case. Yeah, he's sleepwalking, even though that's not what's supported, because that's the easy thing to do. But it's not the right thing to do. The right thing to do is to look at the evidence and the facts, which is what we have built our case upon, and convict the defendant. Let's talk about some of these facts. We know that he went into her room at 4 in the morning and stabbed his sister twice in the neck. We know that the day before is when he got that knife. We know that he set an alarm right after getting that knife to get up in the middle of the night. We know that when he went in there and killed her, that he had the pillow over her head. We know that when he called 911, that she'd been dead for a while. How do we know that? 7 minutes into that 911 call, she's gray. 10 minutes into that 911 call, when officers get there, she's pale. And they want to say, oh, she just could be really pale. No. I want you to look at the screenshot from this body cam. This is not the color of skin of someone who is just pale. It is the color of the skin of someone who has been dead a long time. Look at the difference between her and her brothers.
To her mischaracterization of the evidence as it was presented to the jury.
So the jury heard the evidence in the case. You all get to make the determination who you find credible. Please remember that both opening and closing statements by both sides are merely their opinions of the case. Y'all are the finder of the facts. You may continue to rule.
Thank you.
We also know that the blood had begun to coagulate. These are not things that happen immediately. She had been dead for some time. When EMS arrived, Dr. Faddick told you after reviewing those reports, she didn't have a heartbeat, she wasn't breathing. Just because the defendant is saying on the 911 call she's breathing doesn't mean she actually was. We know what she looked like. There's a reason the officers didn't step in and do CPR. They got there and they saw the evidence. They've seen plenty of dead bodies and they knew that she was dead. We also know that he was awake. Look at his phone. He was awake. And one of my favorite things that defense told you is that we're trying to take facts and make it fit a narrative, which actually is what they're doing. Their whole case is based off one expert's opinion, an opinion that is built on exceptions and assumptions. He had a conclusion. His conclusion was he was sleepwalking. But he had to start with that conclusion because what else could it be? It can't be self-defense. She's asleep. Can't say it wasn't me. And he told you I was dreaming. So here they are, a parasomnia. They have to make it fit, and so they found an expert to do that.
I'm going to object, Your Honor. We don't have to do anything.
So the burden always lies with the state of Texas. The defense has to prove no evidence in this case. Again, the facts, the law is written by this court, and you're to be governed by that law. That'll be sustained. You may continue, State.
So let's talk about some of these guidelines for sleepwalking. First, typically, you don't have any memory. But Benjamin Elliott, he's the exception to that. And they want to say all he remembers is the knife. What he told you was my last memory. was the feeling of the knife going into her neck. Not my only memory, my last memory, implying that there was more that he remembered. And think about your own experiences with sleepwalking. I used to sleepwalk. I don't remember it. My parents had to tell me. My kids would sleepwalk, but then they would wake up and have no memory of it. Somehow, Benjamin Elliott is the exception to that guideline. Let's talk about another one, dreaming. He says it was a realistic nightmare. Not, I had this little mood going on or a slight feeling. He's saying a realistic nightmare. And also, why are you dreaming about stabbing your sister? That's his dream? That's the nightmare that he's reenacting?
I object to the continuous mischaracterization of what the evidence shows.
As I've told the jury before, you guys heard the facts of the case. Y'all get to draw the conclusions based on the evidence. That's what we're here for. That'll be overruled. You may continue to state.
But not just these exceptions, and there's some more. Let's talk about some of the assumptions they have to make. Well, we have to assume that he got into his N3 sleep exceptionally fast. They want to point to the sleep study where he got into it in 11 minutes, when there's another sleep study where it took him 33 minutes. And I want to remind you that sleep studies aren't your normal sleep. You're in a lab, you've got a bunch of stuff all over your head. You're not replicating your normal sleep. And I want you to think about the time that they put him to bed that night, 8 p.m. That is a lot earlier than he usually goes to bed. He told you he usually goes to bed 10:30, 11 o'clock at night. Think about it. When you have an early flight the next day and you try to go to bed early, you're pretty restless. You usually struggle to go to sleep because it's not your normal sleep cycle. Could he have done something, perhaps stay up the night before playing video games to make sure he's exceptionally tired that next day at the sleep study to help him get to that sleep that quickly? They also are assuming that he has a trigger. A trigger that not only has to occur, but has to occur in that window. They're also having to assume that that trigger is so much that it wakes him up. We're not the ones assuming anything. They are asking you to make leap after leap after leap to get to the conclusion that they had from the get-go. He also is the exception when it comes to coming too quickly. Typically, because you're coming out of deep sleep, you're going to be unaware of your surroundings for a while. Not the defendant. He knew right away where he was, what he needed to do, all of that. Again, he's the exception. Then we have provocation. They're saying we don't know what happened in that room. Maybe she pushed him. So what they're telling you is that the defendant took this knife, went into her bedroom, got on top of her, and was here with the knife to her neck, and she must have hit him. So that's why he stabbed her? Why were you on top of your sister to the point that she could provoke you when she's asleep?
I'm going to object to the mischaracterization of the evidence. There's no evidence that he was on top of his sister.
Again,
All right, Megan Long for the prosecution, aggressive, just like her partner, very aggressive with their clothes, and just convinced that this young man did this on purpose, set the alarm, and went in there to kill his twin.
Regardless of the fact that there's no clear motive of why he would have killed his twin.
You
She
don't
doesn't
need
care.
motive of care,
She
apparently,
doesn't-
yes. Now, this is a crazy case. Let's be honest, and our viewers definitely are torn on it. This is a tough one. Is that reasonable doubt? We'll see. Let's get a break. We'll get back for the remaining part of the state's closed. You see the clock ticking. They've been at it about a half an hour in Texas. Stay with us.
Grieving widow or mastermind behind a murder.
Monica Cimentelli is accused of plotting to kill her husband.
Famed celebrity hairstylist Fabio Cimentelli.
Prosecutors say she and her lover killed Fabio to collect a big life insurance policy.
The defense may say she's a bad woman, but she wouldn't be involved in a murder.
It's a whodunit Hollywood story, but will there be a twist that no one sees? The Celebrity Stylist Murder Trial. Today, only on Court TV.
Welcome back to Court TV Live. The jury has now been deliberating for 29 minutes in the case of a Texas brother who's accused of killing his twin sister.
Prosecutors say that Benjamin Elliott stabbed his sister Meghan to death back in September of 2021. The defense says Elliott was still asleep when he stabbed her and woke up, found that his knife that his father had given him was in Meghan's neck.
Let's go back in. We're picking up where we left off with the closing arguments. So we're a little bit behind, but while the jury is deliberating, we do want to show you every moment of these closings. And right now, it's the state's rebuttal. Final word to the jury.
Of the case, from the counsel's opinions with respect to how the incident went down is their opinions. You guys heard all the evidence in this case, and that will guide you. You may continue. It's overruled.
I want to talk about the history, the family history of sleepwalking. I was pretty shocked when they decided to have their expert talk about the fact that his dad had a violent episode coming out of anesthesia. Anesthesia is not sleep. Anesthesia is a medically induced coma, not sleep. But they wanted to put forth in front of you to try to confuse you. Look, his dad had this violent outburst, so therefore it's possible that the defendant did too. That's misleading you as to the facts and the evidence. Then let's talk about his history. This whole donut thing, it sounds more like he probably got up to eat a donut and then got caught. But think about this. That happened when he was around 12 years old. He then goes 5 years without sleepwalking again. In his next episode, he just happens to stab and kill his sister. But the biggest thing that they're hanging their hat on is the lack of motive. And what they're trying to confuse you with is the fact that I can't sit here and tell you what the motive is means that there is not one. And they are two totally different things. The best person to tell us why they did something is the defendant. He's not going to tell us why.
Judge, Your Honor, our client does not have to testify and tell the jury anything.
That's a stain. Continue.
The best person to...
Your Honor, I would also move for mistrial at this point.
That's declined. Denied. Continue. You have 15 minutes.
Thank you. The other person who would best be able to tell you why something happened is the family. But we have seen time and time again that they have built a wall around him, a wall that they started to build as soon as this happened. And we all know, we never know what is going on behind closed doors. They want to say that this family life was perfect. It was Disneyland. And you know what? I hate to bring this up because I feel bad saying it, but the defendant brought it up in his statement. Meghan tried to commit suicide. It clearly wasn't all rainbows and unicorns and happiness that they want you to believe. Something else was going on, but we don't necessarily know what happens behind closed doors. Think about when you watch the news and people go out into the neighborhoods and they say, I had no idea this person could do this. I never saw this happening. It's because we don't know what was happening behind closed doors. I was a prosecutor in our child abuse division. I remember all the time we would wonder, why would a dad abuse his kids? Why would a brother abuse his sister? How can this happen? Just because you don't understand the why doesn't mean that it's not happening, and you can't stick your head in the sand and take the easy way out. And while I didn't give you motive, I did show you premeditation. It's no coincidence that the knife he used to kill his sister was the very knife he got the day before. It's no coincidence that after he got that knife, he went to go set himself an alarm to go off in the middle of the night. It's no coincidence that the exact number of steps he took that night at 4:08 was the exact number of steps from his door to his sister's door. The facts support the theory that the defendant was awake when he killed his sister. I want to talk about the blood spatter and the pillow, because there is no blood spatter in that room. There should be blood spatter in that room. The reason there's no blood spatter is because there was a pillow over her head. Even if you were to come to exceptionally quickly, you would still have blood spatter. They can't escape that. They want to attack us for saying that he must have been, that we're making things up, saying he took a nap. We're saying he took a nap because he told us he took a nap. In his statement, he says, when Deputy Munoz says, "Man, you're not tired," he says, "Yeah, I took a long nap. I probably got about the same amount of sleep as I normally would." How am I making up that he took a nap? He told us he did. That's why we're saying he took a nap during that period. But no, they keep bringing in the parents to try to fix their problems. And look, I'm a mother, and so I understand wanting to protect your children. I get it. I know if something were to happen to my kids, I would want to do everything I could to protect them. Because you just can't help it. As a mother, as a father, that is your instinct. But you as jurors can't let them get away with it. They came in here and they want to say, it's the lawyer that forced the search warrant. Sure, he's the one who told them, but who called the lawyer? You don't call a lawyer for no reason. It's not like the lawyer was next door and just strolled outside and said, "Hey, what do you guys, what's going on? Do you need some help?" They called him there for a reason. Because as the defendant's father told you, we called him to represent myself, Kathy, and Benjamin. They have been protecting him from the get-go. And they came in here and did it again with the search history. Again, we don't really care what he was deleting, but then his dad gets up there and says, no, I told him to delete it. What parent tells their teenage kid, "No, I don't want to know what you're searching on the internet, delete it"? Are you kidding me? Every parent in here knows I want to know exactly what my kid is looking at and exactly what time. And then with the whole taking a nap. Oh, no, we were playing video games all day. We just said he took a nap because he told us that. And because it helps our case, they've got to make it go away. And then his mom comes up here and says, oh, no, he sets multiple alarms. But the problem with the alarm thing is, if you need multiple alarms to get up, you're not going to then go turn one off unless you're awake and you're going to stay awake. If he truly was planning to go to sleep and that alarm was something other than an alarm to make sure he was up after his dad went to bed but before his sister got up to kill her, he would have left it on. He would not have turned it off, but he did. The person who needs multiple alarms to get up turns off an alarm. He is awake and he's going to stay awake. I want you to look in this courtroom. There are so many people here for Benjamin. There is not one person here for Meghan.
I'm going to object to that.
I'm going to address two things. We don't do outbursts in 1 second. So if you can't control it, you have to get out. You have to leave. Second of all, again, that's her opinion. Like I said before, you guys are the facts in the case. You guys make the determination. I give you the law. You may continue.
Thank you. For 4 years, I have carried Meghan with me every day. For 4 years, we have had her, but I can't carry her any further. I have to give her to you. In her room, she had a poster, and it said she needed a hero, so that's what she became. Meghan can't be her hero. She wasn't given the chance. So you have to be her hero. You have to be the ones to be there for her, to stand up for her, to protect her. Don't make a decision based off assumptions and exceptions. Make a decision based off the facts. Each and every one of you knows he wasn't sleepwalking. It doesn't fit. They had to make it fit. And to do that, they're asking you to make assumption. Exception to the guidelines, exception to the guidelines, exception to the guidelines. It's clear, the facts show you that he was awake and he knew exactly what he was doing. They want to talk about remorse and calling 911. What remorse? There's been no remorse shown here in this courtroom by him. He had to call 911 because who else did it? There's just 4 of them in the house and now one of them's dead. Just because he called 911 doesn't mean that he wasn't trying to cover it up. He had to, because what's going to happen when everyone wakes up and she's dead with the knife he has? He was going to get caught. He called 911 to set up his defense. Be her hero. Don't leave her out here. Take her with you and do what she is begging you to do. Find him guilty.